welcome to this presentation on navigating redundancies and change management within the workplace. My name's Kent Duffy, lead solicitor and senior employment lawyer here at Employers Assistance. In terms of the agenda today, we'll be looking at various aspects of change management and implementing redundancy processes or restructuring processes in line with New Zealand employment law requirements. In terms of an agenda, we'll be looking at what specifically change management is about, due diligence and developing your business case to support a corresponding proposal for change, the consultation process itself and the key legal requirements about that process, selection criteria and redeployment obligations, which is somewhat of a contentious or very tricky area of this particular subject matter, and also understanding the potential legal risks or potential risks at a high level. Change management is essentially the process of planning and implementing changes in an organization. Often it corresponds with restructuring, and that may be internal changes to how a employer's business operates and performs, and that may impact directly or indirectly employee roles or staff roles within the business, right through to redundancies and formally disestablishing roles and terminating the employment of some staff or all staff in some very unfortunate cases on grounds of redundancy. Restructuring, or the word restructuring rather, doesn't necessarily mean that staff are made redundant, but it might mean that their roles are changed significantly as part of a change process. Change management can involve adding new roles, merging roles, losing roles, outsourcing roles or work, buying and selling a business, downsizing, etc. So broadly, change management refers to all of the sort of circumstances or change processes and proposals that sort of make up larger scale impacts on employers' operations and the employment of staff too. Due diligence in developing your business case. This is a really important area of any change management process. Due diligence, planning and preparation are important and really vital to good change management processes. So there are a range of considerations that need to be worked through within this context, in particular legal obligations. So substantive and procedural fairness considerations in relation to the Employment Relations Act 2000 and the various legal tests and requirements that must be met, including good faith when embarking on these sorts of processes. Contingency planning, what if things go wrong, the inherent risks that can come with these processes that sometimes can never quite be extinguished, having contingency plans and arrangements in place if that is required to be relied on if things escalate or implode into protracted disputes potentially. So there's things like being prepared to negotiate confidential settlements, perhaps, and the timings around when those might be implemented, either during the process maybe, strategically if that's worth exploring, or at mediation as a backstop if you need to. The application of potential insurance coverage, if there are any insurance policies that might provide for employment dispute liability, these need to be checked and carefully considered before starting a change management process, right through to an effective ER strategy. These sort of things are part of the due diligence process that really should be done before you do anything. Other options, voluntary redundancy schemes, hiring freezes, managed exits. These are all sort of considerations that might need to be carefully mapped out and thought about before the employer, solidifies and embarks on its change process. An essential point here is that the employer takes time to develop its business case to support its proposed changes. So in summary, this requires a written proposal document be drafted very carefully that sets out the components for change in a simple and easily understandable, digestible version. So basically you want a detailed document. It doesn't have to be a massive novel, but it needs to be well written and sound to support your proposal for change. And that may include supporting appendices in terms of backing up that proposal with relevant information, which is a key legal requirement under Section 4 of the Employment Relations Act 2000. So again, due diligence is key, and preparation of the written business case is equally key and vital to get right before you start a formal change process as an employer. In summary, proposals for change must set out clearly the reasons for change or the basis for change, explain the business rationale, and provide supporting information where relevant. Common mistakes made by employers in terms of managing change processes. These can be broadly distilled to the bullet points that you see on the slide here. So often, decisions here, particularly in terms of redundancies, can be quite obviously predetermined depending on how the employer goes about its process. Often employers rush change processes. That means they don't do adequate due diligence or any due diligence at all, and fail to prepare for the process. Whilst it's pretty straightforward, it is involved and it needs to be carefully and thoroughly mapped out and planned before embarking on it. Generally, that applies no matter how small or large a change process is, particularly where staff are being made redundant. It's important to get the process right. Employers not taking the time to understand their legal obligations and any particular risks. So, for example, employers failing to provide access to all relevant information that supports its proposal. That can be a common one. And the employer failing to articulate adequately or sufficiently in simple terms its actual business case or rationale to support the changes that it wishes to implement and the why behind that. So, these things need to be unpacked and thought about and carefully embedded into your process before going through with it. Rushing the process is another one. Often employers they choose not to do their due diligence and to, potentially just do a truncated process, or in some cases, unfortunately for those employers, no process at all. And where this happens, it can often lead to an open knife that the employer runs into in terms of claims for unjustified dismissal based on procedural flaws and substantive flaws in the reasoning associated with their change processes. Not having a written proposal document that clearly sets out their business case, failing to provide the adequate information to support the proposal. As I mentioned before, there is actually a legislative obligation in the Employment Relations Act 2000, which is also supported by a range or numerous case law on point that sets out this obligation, that where information is relevant, the employer must consider providing or giving that information to employees, or as a bare minimum, how it goes about providing that information. For example, if the information may be commercially sensitive, how is the employer going to reflect that information in the documents in a way that protects its interests but also complies with its legal obligations to provide the supporting information. Where the employer fails to do this carefully, then this requirement alone can lead to successful personal grievance claims for unjustified dismissal. Failing to ensure, compliance with the limited exceptions regarding access to information which are written into the legislation, not right through to not managing the consultation process correctly. So the various meetings that need to occur and the opportunity for the affected staff or employees to be able to give their feedback as part of that process. Typically, a live or very contentious area relates to the application of selection criteria. That's the criteria that an employer uses to determine what roles and employees are going. Usually, where you're going from many of the same roles to few of the same roles, and also redeployment obligations, which are a very real and live consideration in this context. Redundancy is always a last resort, and the short point on the redeployment obligation pieces is that employers are mandated effectively to ensure that redeployment obligations are explored and offered to affected employees where those redeployment options are suitable and available. The consultation process. The consultation process is key to any good change management process. It involves identifying what staff or employees need to be directly consulted with and the timeframes for doing so. It involves the importance of a carefully documented process, and I come back to the piece around having a written proposal document, which is sound and carefully thought out, various letters to support each step of the process, meeting minutes, etc. In summary, a consultation process at a very simple level involves a proposal stage and a formal meeting to that effect, a feedback stage and a formal meeting to that effect, and then finally a decision meeting and a formal meeting to that effect, or to confirm the outcomes. However, that is just a very bare bones or basic roadmap of what is meant by a consultation process, which should occur over sort of at least a 2 to 3 week period as a minimum before getting to a point where staff are given notice of redundancy. There may need to be additional consultation steps in the process depending on the complexity of the change management process or the restructuring exercise itself. So it's just the three-pronged or three-step points on the slide here is just a very high level in terms of what is meant by consultation process. Again, the process cannot be rushed, and a reasonable time frame needs to be implemented. Staff need enough time to be able to digest, understand the written proposal document and the process overall, and time to seek independent advice and engage lawyers or advocates if they choose to. We have a detailed ebook on change management, which can be read, and it's definitely recommended to look at this resource if you're embarking on these processes. It includes a step-by-step process and guidance, commentary, information, template documents and letters to help our members with navigating these processes or change processes. Selection criteria and redeployment obligations. Typically, these can be quite contentious and often complicated. So the caveat there is if this is applicable to your particular change process, it would be well advised for you to get some professional advice or help with navigating this subject area. Like I mentioned before, usually selection criteria applies where you're going from many of the same roles to few of the same roles, and the selection criteria needs to be thought about and proposed to staff before it is implemented for their feedback, etc. And effectively that would determine by way of a rankings or a weighting system which roles are going by way of redundancy. Selection criteria need to be objectives, and like I mentioned before, these generally would impart a weightings or a scoring system which would be used to determine what employees are retained or conversely made redundant following any final outcomes associated with the change process. The employer must carefully consult with effective employees about selection criteria before applying it. So it's vital that employees, if they are subject to a selection criteria, have the opportunity to feedback into any proposals around what the employer is looking at in terms of setting the criteria specifics. So they have the chance to comment on that before the green buttons hit on its application. Importantly, selection criteria should be measurable and it should be relevant to the role. So careful consideration needs to be thought around having objective selection criteria where that is required. Some common examples of objective selection criteria can be last on, first off, length of experience, particular qualifications, skills, and training. They're commonly the ones that employers look to when navigating or implementing a selection criteria. Examples of criteria that ideally should not be used, for example, an attendance record or leave for legitimate purposes, sick leave, bereavement leave, parental leave, leave on ACC, or any prohibited grounds of unlawful discrimination, including being a member of a union. The obvious applies there. That would be not something you would want to be using as an employer as a selection criteria for obvious reasons. Redeployment obligations, and I mentioned this before, redundancy is always an absolute last resort. So where there are other roles that are available in an employer's business, or potentially they become available during the process, there's an absolute obligation for the employer to genuinely consider impacted staff where those staff may be made redundant for those other positions. And a fair process may need to be explored in terms of what staff ultimately offered those roles if they're applicable. It is really important. Failing to get that right alone, even if you get the the consultation process pretty good, can be a ground in and of itself for a successful unjustified dismissal claim. So care needs to be taken, and you need to genuinely explore other redeployment obligations as the employer if those exist. Understanding potential risks at a very high level. So any change process where employees' employment are being terminated, then the risk is as personal grievance claims may materialize. So typically these would take the shape of an unjustified dismissal claim and or unjustified disadvantage claims or personal grievance claims. So it's good to have a general idea of the potential remedies that can commonly be sought by employee or ex-employee claimants in this context. So typically these are for lost wages or lost remuneration, and that's generally up to 3 months, but it can be more subject to the discretion of, say, the Employment Relations Authority. Injury to feelings, compensation payments, or hurt and humiliation, H&H payments vary, but they're typically in the range of 10 to 30k. For sham or botch restructuring, you can generally guarantee that they will be at the higher end of the scale. So it's not unusual where an employer implements a sham process to target, say, common scenarios to target an employee or employees who are poor performers, or otherwise they may have other unrelated issues, ulterior reasons, if you will, for those sort of redundancies if they're found to be unlawful, or sham to be at the higher end, so 30,000 and above, simply for injury to feelings compensation. Then you've got legal costs or legal fees, and also the potential of reinstatement too. So these sort of considerations need to be front of mind in terms of your contingency planning as an employer when embarking on these processes, because worst case scenario, if you fail to get the process right and it is unable to be resolved via a resolution in terms of mediation or beforehand, then it's off to the Employment Relations Authority, where your process would be vigorously scrutinised, and these risks can ultimately materialise as an outcome to those determinations in that context. Also, generally, legal decisions are a matter of public records, so there could be potential brand implications if the employer botches the process up. I guess the sniff test, or the approach there would be: would you want the situation on the front page of the Herald, say, because these cases are often picked up and reported on by various media outlets, including the papers in the Herald. So just something to also be cognizant of when looking at these processes. You've also got the management time. litigation processes, even in the Employment Relations Authority, are by their nature very time intensive and often very stressful for the parties involved, particularly for managers and supervisors who may not have been privy or involved in these sort of contentious legal proceedings before. So there are other intangible practical things that need to be contemplated as the employer, where redundancies may be imminent, say, because these are the considerations that can materialize by way of risks if things unfortunately implode into a protracted legal dispute. Other practical considerations with this, and it just comes with the territory, disengagement, disenfranchisement of other employees, and those practical considerations by way of the impacts or negative impact on staff morale and culture, these sort of things. So generally, a change process where staff are being made redundant is not something that employers do very lightly for these reasons and others. In terms of closing or final remarks, redundancies must be about the role and not the person who occupies the role. So the role itself, there needs to be an adequate explanation in terms of, if you're going to make it redundant, the how and why, what's the reasons that the employer has, and the information to support its view that that particular role or roles are superfluous to its operational requirements. Redundancies cannot be, and although they often are, about targeting employees who are poor performers. If that is the case, then the risk is that quite quickly a lawyer or an astute advocate will tend to pick that up, and they'll do a range of things like Privacy Act requests, etc., and move to position an argument to the effect that that process was a sham and therefore unlawful, and seek remedies accordingly. Redundancies should not be motivated by ulterior reasons. So I've mentioned that, targeting poor performers. They should be able to demonstrate how and why a role is superfluous to the business requirements, and I mentioned that earlier. Really important to ensure and think very carefully about the access to relevant and supporting information. This is really key or critical to any change process if the employer is looking at getting it right. In terms of legal requirements, again, I reiterate that do your due diligence. Take time to prepare, plan, and formulate your proposal for change before starting your process. So there should be a period, and that may even be of weeks perhaps before your actual consultation process, where you're looking very carefully at your due diligence from every aspect, contractual obligations in any employment agreement, collective employment agreement. There may be stuff in the collective employment agreement that needs to be adhered to before you can even start a change process. Having a written document which has been carefully prepared and thought about before starting that formal consultation process. These things need to be weighed up. Consideration of selection criteria and redeployment obligations, as I alluded to earlier, and also obligations around terminated employees or staff. So, you're going to offer employee assistance programs or counselling, job supports. What about redundancy compensation and notice periods? These things need to be looked at before starting these processes, like I mentioned. That concludes this presentation on navigating change management in the workplace. Thanks very much for your time, and I hope you've gained some interesting or useful insights and information into this particular subject area. For further support or assistance and advice, free phone our 0800 number. That's 0800 15 8000. 0800 15 8000. Alternatively, you can access our website and the corresponding resources at www.employers.co.nz, including our comprehensive ebook, which is essentially an information pack to support our members with this particular area or process, including step-by-step guidelines and a range of templated documents and letters. For further support or help beyond that, there is also the option for discounted member rates for formal assignments or legal work, and that can be accessed independently through contacting us. Thanks very much for your time today. Have a great day. Bye bye.